Good afternoon again. It's Friday afternoon, so um, the subject for today's episode is what will happen if your spouse or husband or hubby does not want to go with you to the interview. Meaning you're married to a U.S. national, lawful permanent resident, or citizen. The pertinent I-130 petition has been filed for you. The adjustment application for green card residency has likewise been filed, and you've been scheduled for an interview, and all of a sudden your spouse or husband does not want to go with you. So I guess you're in a dilemma and what to do now. Well, first things first, it depends on whether the marriage could actually be proven to have the required bona fides, whether it's a good, genuine marriage. That's one thing that we have to prove, obviously. Second, as to what kind of relationship did you have with your spouse. The thing is, normally in cases like this, if there were incidents or various reasons that would amount to cruelty or abuse, then you could actually file a self-petition as an abused spouse. When I say abused spouse, I'm talking for both sexes. So it could be female or male. And you have to document it, prove it. Abuse is a very generic term, so I guess you have to consult a lawyer and discuss it in detail as to how you would characterize your relationship with your previous spouse. Obviously, if there were like incidents of violence, then it may cross a certain other application for which you may be eligible for, such as a victim of a crime. That's a separate EU visa. That's a subject matter for another episode. But in this particular case, we're limiting ourselves to a adjustment interview. The first one that you're supposed to file with your USC or United States citizen husband or wife, or lawful permanent resident husband or wife. Now, I also have to digress a little, because even though you have your green card, later on, if the green card or your LPR status has been approved within 2 years from the date of your marriage, there's such a thing as a conditional green card, meaning there's a requirement under the law when it was changed, where 90 days before the second anniversary, and that small window, you have to file a petition to remove the conditions. It does not mean that your green card is actually conditional. It is only conditional in the sense that the law requires you to file a petition to remove certain conditions, apparently to prove that the marriage is still going on, and also a way of checking whether the marriage was actually genuine. Now, at this particular stage, I'm talking about at that second interview, if ever you'll be called, meaning you get your green card, before the second anniversary, you file the pertinent petition to remove the conditions, and then if you'll be called for an interview for that purpose, again, your husband or wife decided not to go with you. So what to do now? Well, you could still proceed with it, as I said, as an abused spouse if there were such incidents, or you were divorced, it was a good faith marriage, but unfortunately it did not prosper or succeed, and ended up having a divorce, or the marriage was actually terminated. So everything's well as long as everything's in good faith. In any case, at the end of the day, there are details that you really have to discuss, and I would recommend you to consult a lawyer regarding this. All right, thank you and have a nice weekend.